Welcome to the Business SOS podcast. This is Rich Sierra, president of the Florida Small Business Legal Center. This is episode 153 of the podcast. Thank you for listening. As you're aware, I'm a business litigation attorney. I've been in practice now for over 21 years, and I've seen quite a bit of litigation. And throughout the podcast, I go through various topics. And in this one, I'm going to revisit a topic that I've done before, but it's worth repeating simply because it's just the mistakes keep happening. So I want to kind of make you aware of some of these mistakes. And in the event that you're in litigation, hopefully you won't be, then you have an awareness of what to do in this, what is subject I'm going to talk about today. So the topic today will be 10 common mistakes business owners make when responding to discovery. And if you recall in prior episodes, discovery is very broad in litigation, so includes what is called paper discovery. That's into request for admissions, request for production of documents, request for interrogatories, depositions. That's the very oral discovery that we ask questions or questions asked about you. And within that, there's also, you can actually have what is called deposition de testiculum, which asks for documents to be produced at your deposition. So there's a lot, when we talk about discovery and litigation, it's very broad. But I'm going to focus today on responding to written discovery. I'm not going to talk too much about depositions because we covered that subject in the past, and that's a podcast in and of itself. But I want to talk more about written discovery, deadlines, the completion of that discovery, and how important it is. So the situation here that I want to present to you, say you have been sued, you receive your service, your summons, you hire an attorney, and then with that complaint, which is the lawsuit itself, you have what is called discovery request. You have your request for admissions, request for production of documents, and request for interrogatories. With that service, is usually a deadline, and it varies whether you receive that discovery with the lawsuit or you receive the discovery throughout the course of litigation. Generally speaking, in Florida, you receive the discovery with the lawsuit. You have 45 days to provide the responses. If you have received the discovery request throughout the course of litigation, you have 30 days to respond to the discovery. Now, I want to talk about those deadlines important. That's deadline, the 30 days, is the deadline that your attorney has to serve that to opposing counsel, complete it. So your deadline cannot be 30 days. Your deadline to provide the responses to the attorney would have to be 2 weeks at the most, because your attorney has to review that discovery, have to help you prepare those answers, have to prepare objections to them, have to go through various drafts of the responses, get it finalized, and then get it served to opposing counsel. So I see it often that a mistake that business owners make is that they procrastinate in the discovery responses. They see 30 days, and I said, okay, I have a month to do so I put it aside. And they have, in interrogatories, you have 30 questions, you have 25 questions, you have subparts, and those questions have to be answered under oath. And what happened in this case, then you had the 25th day, discovery has not been produced to your attorney. 27th day, then you start getting calls from the attorney and paralegal saying, where's the discovery? It's due in 5 days. I'm getting it to you. You provide some quick answers and send it to him. And the attorney inevitably would have to ask for an extension to opposing counsel to get the discovery prepared. So one of the mistakes that I see here that happens is that mistake number one is that the business owner misses the deadlines uh, because it's not important, people are busy, but it is your case. So these deadlines are strict, and do you not comply with them, yes, you can ask for extensions. That's something we like to do because obviously we got to reciprocate, but we prefer not to ask for them if we don't have to. If the deadline is missed and there's no extension and it's done, uh, you don't pay attention to them. You don't get back to your lawyer. Then the opposing side can ask for a motion to compel discovery and sanctions. And it can escalate from there only because you did not respond to some questions on your own case. So it is important to do that. And a request for admissions is even more problematic because you do not respond to this request for admissions within the 30-day period. Those admissions can be deemed admitted. And those admissions are not for your benefit. When somebody sends you requests for admissions, they want you to admit, if you admit to those, they can move for summary judgment very quickly. So most likely those requests for admissions will be denials. All you're going to do is deny. So to the extent that you procrastinate on the request for admissions, that's just not acceptable. That can easily be done very quickly and respond to it and move on. So getting back to your attorney with those is very important. And I know that you are busy and you put this aside, but when you have your paralegal and your attorney chasing you to provide the answers to your case, it becomes more difficult for the attorney and to staff to help you. So my advice, if you have requests for admissions or requests for interrogatory production, set time aside to really focus on this. Focus and do it in the morning when you're fresh. Don't do it at the end of the day when you're tired, when you're close to closing your business, you're exhausted. Just set up a time in the morning to get it done. And what I do in my office, I set a time with my paralegal, Richard Fariello, to go ahead and go over the drafts of this discovery and begin to prepare them. Once the drafts are prepared, then I review them and we go over changes and begin to prepare the various drafts. And it's also important to note, and that goes through all the pleadings that attorneys prepare. When you see the final product, it doesn't go from the first draft to a final product. It does not work that way. You go through a lot of various drafts and variations of the same document until the attorney feels that it's ready to be finalized, it's in final form, and it's ready to be approved to send out. So you need to allow time to the attorney to work through those discovery responses and to prepare those drafts. So it's not as simple as it looks. You see the final product, but it takes a lot of work because every question is important. Every question that is asked in the discovery is important. So answering those questions thoroughly and methodically and intentionally is important for your case. This also goes for the organization of documents. There's some now because of the amount of documents we prepare with text messages, emails, invoices, pictures, we have a number of combination of various data or documents. I'm going to use that documents in a broad sense that are included in a request production or are responsive to a request production of documents. And it is not uncommon for for production requests that come with like 50 items. It is overwhelming. That's why setting time aside to go over those requests is very important. When we prepare those requests, we do not know whether you have those documents or not. There's documents that we believe they're relevant, likely to lead to discovery of admissible evidence. They're important to the case. And some documents you may have. Some documents you may not have. Some documents may be responsive to more than one request. The request might be similar, might be duplicative, but your attorney will do that. So giving the attorney here are all the documents and giving him a Dropbox of everything in your case without proper classification or proper indexing it's just not effective. The better approach is to go through those documents. Say this is responsive to request 3, 5, and 7. This is responsive to number 3, number 4, whatever it is, and begin to match the response to the likely question, the likely request. This will give your attorney a better guidance on how to organize those documents to present to opposing counsel, but it's also helpful to him, to your attorney, in preparing the case. Because you can have cases that you have thousands of documents. We just recently did exhibits for a case that's over 1,500 documents, for trial. So just to give you an idea. So it's important for you to have those documents prepared. You can organize them. Your attorney will give you perhaps a Dropbox for you to upload them. And then he can, work with the paralegal or the staff to organize them, to present them in proper form. So your deadline is not 30 days. Your request, a discovery request, you should be working on that pretty much within the first week to have a preliminary answers or preliminary set of documents being presented to your attorney. But don't let it go past 2 weeks because it's going to put your attorney in a tremendous disadvantage as to getting things ready. Because he's going to go through those discovery a number of times to make sure that it's complete as possible. And you have heard me say this before. If you got to provide everything to your attorney, don't make the judgment call what you believe is not important. If it is asked, the question is asked in a discovery request, you got to provide it. If you feel that something is a confidential document or something that may not be relevant, bring it up to your attorney, let the attorney make that determination whether or not that's something that has to be objected to or subject to some type of privilege that doesn't have to be disclosed. And if so, your attorney will know how to handle that piece of information. But don't withhold a document and don't tell your attorney that you have it. It becomes problematic later because if there's any type of email exchange that you had with someone else that is relevant to the case, most likely the other attorney has access to the document as well through the other side. The last thing that you want is that you're in a deposition, and there's a document that is being presented to you that your attorney has not read before. That becomes problematic because the attorney has no idea about the document because he did not read it before. And especially if it's an email exchange where you were involved, because he didn't have the time to prepare you for that particular document, so that email. So if you have an email, even if it's something that might not be helpful to your case, let your attorney know. Your attorney would know how to handle that, should know how to handle that piece of information. But if you have it, the other side has it too. It's even worse. If you withhold documents, then you're dealing with a potential sanctions, potential spoliation of evidence, fraud upon the court, which is a higher standard, but it's not worth it. Let your attorney know, and then the attorney can make a determination how to handle that. Also, let me go to mistake number 2. Not reading the request carefully. Okay? The discovery requests are written in basically legalese. So they're asking specific questions from you, and every word matters. So you have to read the question carefully. The way I handle things is this. Things that are obvious, you do a number of passes. You look at the first pass of the discovery request, and let's talk about request for productions first. And if you have the document, I'm going to give you an example. If you have it's a contract dispute, you're the defendant, the side is the plaintiff, okay, and they want a copy of the contract, which that you had with the other side, which led to this dispute. You have the copy. Here's the copy. Okay, so you go through those, your copies of your articles of organization. They're in Sunbase. You download them. I'm giving you very basic examples. The point is, you go through the list, have it, don't have it, question mark. So if it's something that you have, you're ready, you begin to isolate that as have it, I can produce it. It's something that you do not have, but you have what is called custody, possession, and control, meaning you have the ability to get that document. Okay? And I'll give you an example. The cell phone bill records from your cell phone company. They might be online. You don't have them physically available, but you have the ability to download them. That's just an example. I can produce it. Or you can request from the cell phone company to provide them to you, the mobile company. So you have what is called custody, possession, and control. You have the ability to obtain those documents. Fine. Now, if there's a document that you do not, any request for production that you do not understand, put a question mark and move on to the next. If it's a document that you do not have or does not exist, mark it. Don't have it, doesn't exist. So you begin to narrow down. So from 50 requests, you may have 30 of those documents, 10 you can obtain through third parties, and maybe, I'm doing the math here, another 10 you have questions on or do not exist. So when you had this big list of documents, now you're dealing with a more narrow set that might need some more attention and maybe clarification from your lawyer. So when you look at the discovery, it is overwhelming, it is stressful, but my suggestion is break it down in smaller chunks. So that way this big, massive project that you had becomes more manageable. And that's the way to handle it. And then we begin to prepare as documents come in, responses come in, and we still preparing those drafts of documents so we don't have to maybe do it all at once. So drafts are prepared as documents come in. Not reading the question carefully, that goes also to interrogatories and admissions. And the same rule applies for interrogatories and admissions. Okay? And again, you're going to do drafts anyway to the attorney. The attorney will make the final determination how it's going to be presented and what has to be changed. That's between you and your attorney. But a mistake that I see here, there are two things that I see when people are answering interrogatories. They read it very clear. They read it quickly, do not understand the question, and begin to write a narrative of everything that happened with the other side. When it's asking you, provide the date that you enter into the oral agreement with so-and-so, it's asking you for a date. That's all you have to write. It's not asking you to provide a narrative, explain fully with specificity X, Y, and Z. So reading the question is important in answering what is precisely asked, not expanding, obviously not withholding, but focusing on what is being asked. Your attorney will know what to object to. If it's a question, again, an interrogatory you do not understand or not clear about, put a question mark to discuss with the attorney. But if something that you know is clear on this face and you can go ahead and answer it, just answer it. The idea is to narrow those questions down and you begin to complete the assignment, complete the task. Another mistake that I see is failing to preserve documents. Once you know that you're about to go into a lawsuit or you anticipate that you have a legal dispute, you have an obligation to preserve those documents. Don't delete anything. Don't delete emails. Don't delete text messages. Don't wipe out your phone. Okay? You have an obligation to do so if it's in anticipation to litigation, but you're going to be asked to provide those documents. Okay? The same thing goes to the other side. Because once they ask for that information, you say, well, I deleted those emails knowing that I have a lawsuit, then you're dealing with spoliation of evidence, and you can have sanctions imposed upon you by the court. It's just not worth it. You're also making the attorney's job more difficult by deleting documents that might be helpful to your case, or being careless about, I get, in terms of text messages, you say, why delete text messages after, certain 30 days, for example, where I've heard I deleted my email, so I don't keep my email inbox is deleted every 30 days, something to that effect. So when you don't have documentary evidence, it makes it more difficult. And if the other side has it, then it'll be difficult to really prepare for your case. So use common sense. Don't destroy evidence. Don't delete any emails. Don't shred files. Don't wipe the phones. Just preserve the evidence. Mistake number 4, which I've covered, I think I just covered briefly, is that, oversharing. That when you're asked for interrogatories or admissions or even production requests, respond to what is being asked. Don't expand on that question. You want to talk to your lawyer about a context or an explanation, discuss it with your lawyer, and then your lawyer will determine whether that particular piece of information belongs in that question. So it is important to know what you're being asked and understand the question. And, often I say, well, why do you, I ask my clients when I see a draft coming in, why do you answer this way? That's what I thought I was being asked. Don't make the assumption about what you thought is being asked. Just understand what the question is. And if you have any questions, have the attorney clarify the question for you. Very important. I mentioned this before, document dump. You provide everything. Before it used to be like a huge box with documents. Now everything is electronic. So, you get a Dropbox and everything is basically uploaded in a Dropbox or a box folder, and we're supposed to decipher where each particular document belongs to. It's like one of those, when we in middle school or high school, you have this matching type of test. This belongs here. So it's not a matching test. So you know the facts. The attorneys know the law. The attorney's not going to know your business or the facts in this case better than you. You lived it. As the case progresses, the attorney's going to have the history and knowledge base about the case because he has spoken to you, has taken a couple of depositions, has looked into discovery. You have a number of conversations. So it's going to begin to understand what transpired that led to the dispute. But initially, he's not going to because he did not live that. You lived it. So you providing a bunch of documents to the attorney for the attorney and the paralegal or the staff to try to figure out where they belong, it's going to be very time consuming, very confusing. It's going to cost you more money because the attorney has to spend more time deciphering these documents and trying to match where they belong. So do yourself a favor, do the attorney a favor, and label what you send. This belongs to question number 3. This belongs to question number 4. This one may belong to 7. I'm not sure. That's fine. But you begin to identify these documents and categorize them properly by response. It also is helpful to your attorney in the preparation for trial as well. Mistake number 6 is not objecting where you should. This one, the objections really belong to the lawyers. But if you have any issue regarding a specific question or document that you feel that should be objected to, bring it up to your attorney and explain the reasons why, and then the attorney will determine whether or not it will be a valid objection or not. It could be an objection of relevance, whether the document they're requesting or the interrogatory is relevant to the cause of action, whether it's a question of privilege, whether this information that they're requesting is privileged communication between you and your wife, you and your attorney, you and your CPA, you and your priest. I mean, there are a number of privileged exceptions, so we don't have to go over that today, but your attorney will know which ones they are, will make that determination. Mistake number 7, not searching thoroughly for responsive documents. This one has happened to me before. And it goes back to being thorough in your discovery responses at the beginning when your question is asked. And it's happened to me before with clients, has happened to me before with others to the other side, with people that I'm suing or the opposing side. If you're given a discovery responses, you have an obligation to discovery request. You have an obligation to do a thorough search. And it's actually better at the beginning. Go through everything, go through the emails, go through the documents to make sure that that first response, it is as complete as humanly possible. So you don't have to go back and do it again. Because what happens is that you're about getting ready for your deposition. You go through the documents that you have produced and requested production already. The depositing side is reviewing them and preparing to ask you questions of those documents. And then you say the day before the depo, oh, by the way, I found some new stuff. I forgot to send you this information, this document or this email. What is it? So, and that's the day before the depo. So clearly, by not providing that, if that information is relevant, it should have been produced at the beginning, then the attorney would have to do a supplemental response to that discovery request and alert the attorney, hey, just to let you know, there's something that should have been included and it was not, here it is. So, and it becomes more problematic later on. So you have an obligation to do a thorough search, and it's actually a good idea to do it right at the beginning. It saves you time and money. Mistake number 8, not cooperating with your attorney. I think that it is important that you and your attorney are on the same team and cooperate. Understanding that discovery requests are important, especially interrogatories are under oath. So you want to respond to those clearly. And if the attorney says, I want this in a week, and we're going to begin to work on this in 2 weeks, I want that first draft. In 3 weeks, I want the third draft. Pretty much 3 days before the deadline, get the final and get it out. So there's specific timelines there. And meet those deadlines with your attorney. It's very important. If you don't, what's going to happen is going to have a bottleneck and your attorney will need more time. You're not the only case attorney has. If the attorney allocated a certain amount of time for you, if you do not comply with his deadlines, then you have to create a bottleneck in his schedule, which inevitably will have to request an extension of time to respond to a discovery and properly prepare it. So cooperating with your attorney and with the staff is important, and making sure you schedule time to get this done because it is your case and it is important. Another thing here that mistakes that people made, and they post things in social media about their case. The social media feeds will be discoverable. It's in the public, and they can ask you to provide all your history. There's a way to do it through Facebook. So my suggestion is don't post anything on social media regarding your case, because people do so, and it becomes an issue later on. The same thing goes with text messages as well. So I want to give you kind of a checklist in this case for discovery. If you received a discovery request, obviously from your attorney, you need to calendar the deadline immediately when it's due. But also set an internal deadline of 2 weeks. And my suggestion is schedule an appointment with the attorney, first with the paralegal, to go over some easy questions, things that they don't need the attorney to be involved because the attorney will get involved anyway. And then schedule an appointment with the attorney to go over those questions before it goes out. Your internal deadline should not be more than 2 weeks to allow the attorney 2 weeks to prepare and finalize the responses. Do not delete any emails, text messages, any type of documents or communication. Preserve them. Read every request carefully, word by word. Search everywhere for the documents. That includes file cabinets, if you still have some, emails, cloud, phone, text messages, social media, and accounting systems as well. Answer only what is asked. Don't volunteer information. Review every document before producing it. Discuss with your attorney whether that's objectionable or you have a privileged objection. Work closely with your attorney throughout the process. Treat interrogatory answers as sworn testimony because it is under oath. And if you don't have the answer correctly, you will be asked that questions on a deposition they can use for impeachment and challenge your credibility. Don't forget electronic evidence. That means preserving phone records, either your cell phone records, your cell phone, text messages, preserving all the evidence. More importantly, share all the information with your attorney. And if it's something that might be something that might not be helpful to your case, discuss it with your attorney right from the very beginning. As I said before, let your attorney know the good, the bad, and the ugly, so the attorney will know how to handle it. You do not want your attorney to be surprised on anything. They should not be surprised in discovery. So the more thorough you are, the more candid you are with your attorney, the better for your case. I think the bottom line here is take discovery seriously. It is your case. It is important. You know the facts. We know the law. And we will learn your case as we go along, but you lived it. We did not. So you will have nuances. You will have the details that we don't have because you actually lived the case. If you have any questions about anything we talked about and the importance of discovery, you can reach me at rich@richsierra.com. Again, it's rich@richsierra.com. Our phone number is 866-842-5202. If you like the podcast, please share it with your friends. Give us a review. Appreciate a 5-star review and some comments. If you would like to learn more about what we do, my website is floridasmallbusinesslegalcenter.com. Check out my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for your local bookstores as well. We're also, if you'd like to see the video of this podcast, we're on YouTube at youtube.com/@RichardSierra. We're also on social media at FSB Legal. Until next week, this is Rich Sierra with the Florida Small Business Legal Center. And remember that my goal is to help you succeed.